Well, just thought I'd try to do a little bit of a online um, YouTube to try to go through the chapters and give you a little bit of kind of a mini lecture on the text. So I thought I'd start with chapter 6 on substantive due process. I'm just going to go through the book and give you the things I think are the most important things for you to get out of this. And if you've got any questions, just give me a call. Chapter 6, beginning with the due process. This is chapter 6 is student due process of discipline. The two things that really you've got to understand about this is the difference between substantive due process and procedural due process. Substantive due process deals only with suspensions, and that's anything up to 10 days. And all, really simplistically, all substantive due process is that you must tell the student what the charges are against them and give them a chance to respond. That's it. You have to do nothing else. There's no explanation, you don't have to present evidence, you don't have to give them anything other than just say, here's what you did, here's what we're charging you with, and do you have anything to say about it? And that's all substantive due process is. That's the only level that you have to do on anything up to 10 days. Procedural due process, however, is if anything over 10 days, and that's an expulsion. The reason you have to do procedural is that you are constitutionally you're depriving that student of a right to free education. So when you're depriving of that over a long period of time, you have to do procedural due process. Now, if you look in your student handbook or if you look in your principal's office, there's a whole litany of paperwork that you have to go through with that, and you have to give them a chance for a hearing. And as we talked a little bit about, and we'll talk a little bit about in this chapter, it is not a quasi-court setting. In a procedural due process, there's a time frame that you have to follow, but it is not a court of law, and the students really have no rights to an attorney present in the hearing, and they have no right to cross-examine witnesses and that sort of thing. Let's see. Notice of hearing. You have to make sure that the thing that you have to understand in procedural due process, the important thing is that you dot all your I's and cross all your T's. As long as you go through the process and you do everything that you're supposed to do through the process, the court will not overturn what you're doing. The only thing you're going to get in trouble on an expulsion is if you do not follow proper procedures, hence the word procedural due process. So make sure that you keep great paperwork and make sure that you document everything you do. And there's a time frame that from notification, there's a time frame for the hearing to be held and all that. As long as you do that, the courts will not overturn what you're doing. Now, one of the things that's important on this is your hearing officer and who you appoint to that, and the corporation has to have a hearing officer appointed. Many times that's a principal, like if you're an elementary principal, many times it's a high school principal that will serve as your hearing officer. One important thing to remember about this is in Indiana, school boards had to hear any kind of an appeal on an expulsion. Now in Indiana, it is permissive, not mandatory, that school boards hear the appeal. So if a student appeals the decision of the hearing officer in your expulsion, basically the final authority is the hearing officer unless the board chooses to hear appeals. And you might check that when you do your school board policy handbook review. You might want to look at that, because as a principal you really don't want school boards over hearing appeals to expulsions, because they get too emotional many times, and it's really not a great thing. Let's see. The cases, again, on your cases, as I think it's in maybe on workshop 5 or 6, there's a whole list of cases that I think you should be very aware of to prepare you for your test and that sort of thing. So you ought to get that list out, and as you see a case in any of your cases that you're reading, make sure you just add those to those cases. And also be careful, as I was reading some of your papers, or I read papers, you sometimes get hung up on what the courts have said about admission of evidence in an expulsion or suspension and that sort of thing. Remember that, and we might as well talk about this now, probable cause and reasonable cause. a school corporation or you as a school administrator only have to have reasonable cause to do searches and that sort of thing. So if you under reasonable cause do a search and find something, that's perfectly admissible for you to go ahead and suspend and or expel a student for that. However, probable cause is what the law enforcement officials are held to, and even though you find something under reasonable cause does not mean that that necessarily would be admissible into court because it was not reasonable cause. Don't get hung up about that, because you can still, you as a school corporation or as a school administrator could still throw that kid out an expulsion even though the evidence would not be admissible in court. So be careful when you're reading your cases that you understand that. Let's see. The identity of accusers and cross-examiners. Again, what you need to remember is that the courts over and over again have said that you are not an attorney and an expulsion hearing is not a court of law. Therefore, students who have been expelled and go into a hearing do not have the legal authority or the legal right to have even the names of the witnesses or the evidence that they've presented. They do not have a right to have an attorney present in the expulsion hearing. Now, don't get confused here. They can have an attorney with them, but that attorney should sit outside and not be a part of the hearing at all. And it is not, and of course I've said this over and over again, it is not a quasi-court system. You don't have to have, it's not a court. It's just, again, it's a disciplinary procedure. On waivers, that was one of your terms that you had. A waiver in Indiana now, a student and a parent both have to waive the rights to a hearing, and that's basically giving up their right to a hearing. And again, I'd be real careful about this. If you go through an expulsion, and here, remember this: if you're going through an expulsion and a parent comes in and says, well, we're just going to withdraw our child because we don't want them to go through the expulsion hearing. Well, no, you can't do that. You don't let them withdraw to avoid an expulsion hearing. You tell them that they can waive their right to a hearing, but you're going to still have that hearing. You're still going to go through expulsion. They can't just quit school and forget about the discipline. The reason you can do that, the reason you want to do that is what would happen if they would quit school one day, so you throw away or you don't go through expulsion. And then so they say they come. That's on Friday, and they come back Monday and say, "Oh, we decided to re-enroll." Just go through and go through the expulsion process and let them waive the hearing if they don't want to fight it. Again, substantive due process and procedural due process is both covered in Chapter 6. Make sure on page 157 of the text that you go through and read all of those the notes that Dave Emmert put in there. There's some really good stuff in there, and you want to make sure you go through that. Corporal punishment. In Indiana, corporal punishment is still legal statutorily. The problem is you need to make sure that when you look in a board policy handbook whether or not the board allows corporal punishment. Even though it is legal, if the board says no, then you can't go against board policy and have your immunity, so you would have to, it would have to be allowed by board policy. If it is allowed board policy, then there's a process and procedure that you must go through to administer corporal punishment. In any way, in the way the society is now, I would suggest to you that corporal punishment is probably nearly passé in most all school districts, and I would be, even if it's allowed in your district, I would really implore you to make that a last-ditch and really a last-ditch discipline effort, and then it would be the student choosing that instead of expulsion, or I mean, it's not expulsion, but instead of suspension, even if you use it at all, but I wouldn't even use it if at all possible. All right, the other terminology in this chapter that you really need to look at is void for vagueness. Basically, the courts have said if you have a rule in your school that a child violates and you go ahead and suspend or expel because of that rule, and then you look at, and a court looks at it and says that it was, nobody could understand that it was too vague, it's not specific enough, then they might void that discipline under this doctrine or tentative law of void because of vagueness. That doesn't happen very often, but it can happen. The other thing is a due process in relation to grades and course credits. One of the things you got to be really careful about here is the idea of double jeopardy. And that is, I'll give you an example of double jeopardy. Double jeopardy would be, okay, I'm going to suspend you, I'm going to give you 0 credits for all the time you're out, and I'm going to take away 10% of your grade. That's double jeopardy. You can't do that. You can suspend and you can give zeros for suspension, but the law is very clear that you cannot take away something that the child has already gained or has already earned. So taking percentages off of something they've already earned is not acceptable. While I'm thinking about this, and I don't believe there's anything in this chapter about it, but also many school corporations is another thing you might want to look at in your board policy handbook or your student handbook. Will say if students don't pay their fees, then they're going to withhold grades or they're going to withhold report cards. Legally, you can't do that. The tentative law there is basically you cannot punish the child for something the parent does or does not do. So you might look at that. Somebody says, well, we do that. Nobody's ever gone against us. Well, that's fine. You can do a lot of things if you don't get caught or you don't get sued for it. But the reality of it is that that really isn't legal. What you can do is you can take the parent to small claims court or something like that, but you can't withhold the student's grades because of lack of payment. Let's see. The academic versus disciplinary sanctions, you might want to look at that. And also, the idea is for zeros for missed work, you can do that. What I'd really like for you to think about as an administrator, and I've never had really thought about this till it came up in class once, and that is the idea of zeros. A lot of school corporations are going now to no zeros, and the reason being, if you look at it statistically, just pure statistics, giving zeros are probably over zealous as far as punishment is concerned against a child. And we can talk about that more in class if you'd like, or on chat room if you'd like. That's basically pretty much it for Chapter 6. Again, you got to be careful of double jeopardy. And double jeopardy simplistically says that you can't be punished, twice for the same thing. Okay, that's Chapter 6. I'm going to check and see if this works.